Continued violation of court order. Mazi Nnamdi Kanu seeks 100 billion naira damages against the federal government of Nigeria. Following the continued grandstanding of the federal government of Nigeria, FGN, to implement and to carry out the order's judgment of the Court of Appeal, delivered on the 13th day of October 2022, which in effect, discharged Mazi Nnamdi Kanu of the frivolous charge brought against him and consequently, prohibits the FGN from further detaining him, and or subjecting him to further trial or prosecution by any court in Nigeria. Mazi Nnamdi Kanu has now commenced a fundamental right action before the Federal High Court Abuja, to demand for his immediate release from the unlawful facility of the Department of State Services, DSS, and payment of the sum of 100 billion naira, as reparation for the gross violation of his rights to liberty, freedom of movement and dignity of human person. It will be recalled that following the judgment of the Court of Appeal, delivered on the 13th day of October 2022, which in effect struck out the retained 7-count charge hitherto pending against Mazi Nnamdi Kanu, there is no existing order of a court of law, which presently sanction or legitimize the continued detention of Mazi Nnamdi Kanu, as all courts of first instance in Nigeria has effectively, from this 13th day of October 2022, divested of all jurisdictional powers to either issue orders in respect thereto or even undertake any further criminal trial prosecution against Mazi Nnamdi Kanu. In the originating court process, duly initiated on behalf of Mazi Nnamdi Kanu by our erudite lead counsel, Chief Dr. Mike Oscom, SAN, on the 21st day of October 2022, in suit no. FHC ABJ CS 1945-2022, between Mazi Nnamdi Kanu vs. Federal Republic of Nigeria and ORS, supported by 6 paragraph affidavit, deposed to by Chimonia Emanori ESQ, a legal practitioner in the law firm of I.C. Ejiofor and Company, clearly verifying the fact of this gross violation of Mazi Nnamdi Kanu's constitutionally guaranteed rights, following his continued detention in a solitary confinement in the custody of the DSS in flagrant disobedience of court orders. Mazi Nnamdi Kanu is substantially seeking for the following reliefs, anchored on the foregoing grounds, which the reliefs are predicated upon to wit: a declaration that the continued detention of the applicant by the respondents, from the 13th day of October 2022 till date, is illegal, unlawful, oppressive, unconscionable, and unconstitutional as it violates the applicant's fundamental rights to dignity of human persons, personal liberty, and right to freedom of movement as guaranteed by sections 34, 35, 36, 39, and 41 of the 1999 Constitution of the Federal Republic of Nigeria, as amended, 2011.
He's only a resident of Abuja because that's where you're detaining him. When last he departed Nigeria pursuant to, or he fled to save his life, he last resided in Omai. And events that grandfathered what happened in Kenya happened in Omai. So what are we talking about here? So I'm happy today the court dismissed their objection based on territory or geographical arguments. Also dismissed their second objection based on what is called res judicata. The claim by the federal government is that the judgment of the High Court of Abia State, rendered in January this year, had enveloped this one. That because of that judgment, we cannot proceed with this one, that it will be a double compensation on abuse of process of the court. And the court said no, it cannot be, because the judgment of January this year was about the military invasion of September 2017. The judgment today is about the extraordinary rendition of 2021. So the difference was very clear. So we're happy with the outcome, and I don't think anybody should have any issues with a judgment like this. And with this judgment validating the judgment of the Court of Appeal of 13th October in Abuja, and also validating the judgment of the High Court of Abia State on January 19 this year, the federal government has no more option than to obey. Just obey these court orders and let peace reign. You go to court yourselves as Federal Republic of Nigeria, and your agencies, you take matters to court. And we took you to court. If somebody takes you to court and he wins, obey. So that if you win, that person will obey as well. You see, this is the hallmark of a democratic society. The government, just as the citizens, are supposed to be equal before the law. That's all we're asking about. So these three judgments are very symbolic of a judicial strike against the actions the federal government, the law enforcement actions, the aggressive law enforcement actions that the federal government had levied against the indigenous people of Biafra and the Biafrans and Southeasterners that were caught in between since August 2015. I am keeping tabs. I know the date this thing started. It started August 2015 with the Ball massacre, the Night Vigil massacre, the Python dance, all these things. You know, you just have to stop. You are not doing it right. When someone wants a separate state through a referendum, you listen to him, you talk to him. You don't levy military action against him. If these things are wrong, if IPOB and Nnamdi Kanu are doing something that is wrong, they will not be winning this string of victories before your cause. 3 victories since this year. January 1 victory, January 2022. October 1 victory, and we're still inside October. Second victory came, and there was an international one won at the United Nations, and there is one just about to be won in Britain. Come on, how many victories do you need for you to realize you are doing it the wrong way? The right way is to obey the court order. So peace shall reign. Thank you.
Thank you very much. All right. The barrister just finished addressing the press now at the Federal High Court, Umuahia. So it's victory to all Biafrans all over the world. This is Umuchukwu Writers still reporting to you at Federal High Court, Umuahia. As you can see, we are here and we are winning, just like always. Stay tuned.
An order of this Honorable Court directing the respondents to unconditionally release the applicant from their custody forthwith. An order of injunction restraining the respondents, their agents, privies, assigns or howsoever it's called, from further interfering with the applicant's rights, and or dealing with the applicant in a manner inimical to his fundamental rights guaranteed by the 1999 Constitution of the Federal Republic of Nigeria, as amended, 2011. Compensatory and exemplary damages of 100 billion naira only, against the respondents for the gross violation of the applicant's fundamental rights to dignity of human person, personal liberty, and freedom of movement. An order of this Honorable Court directing the respondents to tender unreserved public apology to the applicant in 2 national dailies, and any other forms of reparation that the Honorable Court may deem fit to grant. And for such further orders as this Honorable Court may deem fit to make in the circumstances. Grounds upon which the reliefs are sought. By virtue of Section 46(1) of the 1999 Constitution of the Federal Republic of Nigeria, as amended, 2011, and Order 1 Rule 2(1) of the Fundamental Rights Enforcement Procedure Rules, any person who alleges that any of the provisions of Chapter 4 of the Constitution to which he is entitled to, has been, is being or likely to be contravened in any state in relation to him may apply to the High Court in the state for redress. The applicant is entitled to his fundamental rights to dignity of human person, personal liberty and freedom of movement guaranteed by Sections 34, 35 and 41 of the 1999 Constitution of the Federal Republic of Nigeria, as amended, 2011. The continued and unlawful detention of the applicant, whose health is daily deteriorating, from the 13th day of October 2022, till date, violates the applicant's fundamental rights to personal liberty, dignity of human person, and freedom of movement, and consequently, illegal and unconstitutional. The Court of Appeal held that the applicant is prohibited from being detained, tried, or otherwise dealt with in Nigeria, for or in respect of any offense allegedly committed by him before his extraordinary rendition to Nigeria. Thus, the continued detention by the respondents is arbitrary and unlawful. The respondents have no authority or justification whatsoever to detain the applicant in complete defiance and disregard to the positive order of the Court of Appeal, discharging the applicant and barring the respondent from detaining and/or prosecuting him. The respondents cannot exercise their power outside the provision of the law and judicial pronouncements, and thus, they are bound to comply with the order of the Court of Appeal, which discharged the applicant. The applicant is constitutionally entitled under Section 35 subsection 6 of the 1999 Constitution of the Federal Republic of Nigeria, as amended, 2011, to the payment of compensation and public apology from the respondents for the gross violation of his rights to dignity of human person, personal liberty, and freedom. We will keep you all abreast of developments in this case as it progresses. Thank you all, Biafrans, and remain hugely blessed. We move. Signed. Saifani Ejiofor, ESQ, KSC. IPOB's lead counsel. 26th day of October 2022. This analysis presentation is brought to you by Biafra in Diaspora Media.